We will proceed now with Estonia, and we will have a look at how the situation is here in my home country. Let's start with the next slide, please. So first, I'm going to talk about what measures there are that employers can take or already have taken in order to tackle this situation we are in. There are some temporary measures, but there are also permanent measures. So first, we will see what can be done temporarily in the hopes of the situation becoming better. Some of these measures are not subsidized by state, but some are, and we will look at that later on. But due to the reasons that some of these are subsidized, there are some measures that employers wish to use more, because in that way they could get also help from the state. So if we start from the first column on the slide, we see there some options that mostly are subject to agreeing with the employees. So these are not measures that can be taken unilaterally by the employer and require a bit of negotiation and understanding and then communication with the employees. Some employers have asked the employees to take out their annual paid vacation during the time that there is no work to provide. This is a bit tricky because in Estonia, all companies have to prepare their annual vacation schedules by the end of March, and any changes in the schedule are basically up to an agreement with the employees. So sometimes you reach an agreement, sometimes not, and then there are also employees who have the right to take a vacation when they want to, for example, during school breaks and so on. So sometimes this might not happen that an agreement is reached. Unpaid vacation is also something that is subject to agreement. We don't have this kind of concept of forced vacation, so employer cannot send anybody on vacation unilaterally. So if employees agree, unpaid vacation can be used. Also, decrease in pay and working hours is possible. But usually it requires a mutual agreement, as these are the mandatory terms and conditions of an employment contract, and these can be, as a rule, changed by agreement. It might help also to use, in some cases where possible, aggregated working hours. This is a concept that would enable to vary the number of working hours per day. But this is also considered as a change in the working hour regime agreed upon in the employment contract. So again, in order to use this, an agreement should be reached with the employees. Some companies have decided to suspend bonus schemes and other incentives provided to the employees. Here it depends whether the bonus schemes and other incentive schemes allow for unilateral change. It really depends on the documentation. But if these have been included in the employment contracts, then of course, again, any suspension or termination or amendments of those types of schemes are subject to agreement. Some companies also have agreed to delay, for example, bonus payments. They are not cancelling the bonus plan, but have agreed with the employees that bonuses are going to be paid out, or even a certain part of salary is going to be paid out when the financial situation becomes better. What I didn't mention here, but what also is used by some employers is actually to kind of lease out their employees to some other company who needs workforce. But there one should remember that it's in that case like a three-party relationship, and when you are leasing out your employees, you remain to be the employer, and you retain all the employer's obligations. So except those relating to occupational environment and health. So it should be also very carefully looked at how these agreements to lease out the employees temporarily are drafted and prepared. So in the next two columns, I have highlighted some measures that can be unilateral. I've referred here to the articles of our employment contracts law, and this is basically how in everyday life HR people and lawyers are calling these possibilities. So first of all, of course, everybody is interested how we can unilaterally decrease pay due to this unfortunate financial situation. We have an option for that in the law. And this is one of the options that also enables the employers to use the state subsidy. It's the decrease of pay in case there has occurred a decrease in work volume. This decrease is caused by unforeseen circumstances beyond the control of the employer, and because of that, the employer has run into financial difficulties and is not able to pay salary. So it has been widely recognized that this coronavirus is an unforeseen circumstance, so this article can be used. And in response to the employer's request to decrease pay, the employees can proportionately reduce their working hours. So basically, they also have the right to work less, but they don't have to. If they want to work more, they can do that as well. But this is a really short-term temporary measure. It can be applied only for 3 months per year. This 3 months doesn't have to be consecutive. It can be in parts as well, but it depends on the situation. It's not possible to have this reduced salary in place with immediate effect. It requires prior notice of 14 days, and during that period also information and consultation procedures have to be carried out with the employees. And if the employees do not agree, they may terminate the contract by giving 5 days of prior notice, and in that case they are entitled to termination compensation in the amount of their 1 month's average pay. This is similar to a redundancy situation, except that there is no normal redundancy notice periods. But this is something that the employers who wish to use this option have to take into consideration, that the employees may decide to leave. Although it is not that common that they leave, because it's not very easy these days to find new employment. Another option that can be used unilaterally is this Article 35, as we call it. It's also grounds for applying for the state subsidy. And this is a clause in the employment law that allows the employer to request the employee to stay at home, and there is no work to be provided to the employee at all. And in that situation, there is the obligation for the employer to continue payment of average salary. This is a bit strange when compared to Article 37, when we have like a little bit of work and we can pay less salary, but in the situation where we have no work, we have to pay average salary. So there are different interpretations of these provisions, and we have yet to see what our labor inspectorate thinks of it. But somehow it seems a little bit unfair, and maybe initially this article was meant to be used mainly for disciplining employers, that if they didn't give employee any work due to some subjective reasons or something like that. But at the moment, the opinion of the Labour Inspectorate is that if there is no work at all, you cannot use this Article 37, but you have to use this Article 35. And then we have Article 38 that can be used actually unilaterally by employee. If the employee cannot work due to objective personal reasons or cannot be expected to work on any other reason that is not related to him or her, then the employee can stay at home, but there is an obligation to continue payment of average salary. This is also a very short-term arrangement, and usually it is used when in normal situation, not in crisis situation. It's usually used when, for example, the employee has some sort of emergency at home or something like that. But in the given situation, it can be used perhaps when employee has been in abroad, has come back to Estonia and has put into quarantine, for example, for 14 days, but it's not possible for him or her to take yet sick leave because there are no symptoms and so on, and there is no idea if he or she has been in contact with an infected person or not. But these are these temporary possibilities now what are available. And on the next slide, we can have a look on some permanent measures, because everybody is predicting that life after the state of emergency will not be the same as we used to have, and for sure it will have serious financial and economic implications for everybody, the situation what we are in now. And so some permanent measures undoubtedly have to be taken. So there are a few available, and what you should remember is that in certain cases when you are going to take some major decisions affecting the employees, either their terms of employment or decisions that end up in terminations or so on. If you are a company employing at least 30 employees, you might have this obligation, general information and consultation obligation. And there are also special information and consultation obligations regardless of number of employees in case of collective redundancy and transfer of undertaking. That would also apply in case of merger, division and transformation. So if due to difficult times there are plans to sell part of your company or transfer the undertaking, then you should also remember to have this information and consultation in place. And in my practice, I have seen that the more you communicate with the employees, the more transparency there is, it's better, and you can avoid a lot of disputes and misunderstandings in that way. So I always recommend not to take this as a mere formality that you have to carry out these information and consultation procedures. So, of course, due to economic reasons, there will be a lot of redundancies. They can be individual or collective. Collective redundancies are triggered when there are certain thresholds reached, a number of employees, based on the number of employees made redundant and the number of the total workforce at the company. And generally redundancies is justified when there is no more work to be provided or there is liquidation or bankruptcy. There are notice periods to be applied. Severance pay, it's usually 1 month, but you should be careful when you have fixed term contracts. The severance pay could be much larger. It depends on how many months there still is until the contract would have expired. There is an exception that in force majeure cases you don't have to pay out or kind of buy out the rest of the contract term, but so far the Labour Inspectorate has said that somehow this coronavirus is not force majeure. So it's a strange opinion, but we will see if we have any court cases about it, and then maybe we have some clarity. Employees who have length of employment over 5 years can have additional benefits from the state. Of course, you should be mindful that there are restrictions on termination of protected categories of employees, so those who have small children, act as employee representatives and so on. Termination should always be in a written notice or an electronic notice. Verbal termination is not legal. And when you qualify for this collective termination procedure, then you should be mindful that this will prolong the whole procedure a little bit. There is a waiting period of 30 days and then 15 days are needed for information and consultation procedures. So you should factor in additional 45 days when compared to individual redundancies. And if we need to change terms of employment permanently, then this can happen only upon agreement. Permanent changes are not possible unilaterally, but if you do it, sometimes employers still do it, then you should be prepared that employees have the right to terminate the contract due to breach by the employer, and then they are entitled to receive compensation of 3 months average salary. So this is something that I would advise to keep in mind. And let's have a look at the subsidies now. Next slide. So there are some special measures that have been adopted, and these are like temporary measures that most probably we will not see them after the end of the state of emergency, but it depends what the government would decide. If it happens so that bankruptcy occurs, then employees can have certain amounts compensated by the unemployment insurance fund. This measure has been always available. It is not something new. They can have their unpaid salary, unpaid vacation pay, unpaid termination compensation up to some extent. There are some ceilings on it, but still they can have some help from the state. It was now decided to make the funded pension contribution of 2% that is usually paid by most of the employees voluntary. As of December this year, this would mean additional burden on employers because they now, as of December, would have to check about each employee whether they decided to continue or not with the contributions. So far, we have had the first 3 days of sick leave free of charge, but to give a motivation for the employees to really stay home when they are sick, now the medical insurance fund will cover also the first 3 days, and this is retroactively applicable as of March 13. There are certain exemptions made from the payment of social tax from the mandatory social tax minimum. This would apply only in March to May. This usually happens when employees are using, for example, unpaid vacation. There is still a certain minimum social tax obligation. Usually that would enable these employees to still have their medical insurance. But now there is the exemption made that this doesn't have to be paid during these 3 months, and at the same time they will still retain their medical insurance as well. There has been a lot of discussion what will happen with the foreign employees. A lot of them had to return already to their home countries. But there is a very difficult situation in some sectors. Luckily, an exception was made for foreign employees working in the agriculture sector. Some employees whose employment contracts end, for example, they would have to leave, but if they find a new employer, they perhaps can stay. So there is a lot of confusion with the foreign employees, and there are really some sectors that would be affected by the absence of this additional help from them, like construction and so on. Some positions require that there are certain competency certificates or health certificates that have to be renewed from time to time, but since It's difficult to arrange for exams or difficult to arrange for medical checkups, then their validity has been prolonged automatically. So certain fields of activities require that their employees have health certificates in place. For example, food processing industry, teachers, care workers, medical workers, beauticians, they all have to have these medical checkups that they are good to work. So now, as there was a suspension in usual medical services during the crisis times, then these health certificates couldn't be issued or prolonged. So this obligation has been replaced by the confirmation on the part of the employee that she's medically fit. And the obligation to file for bankruptcy has also been suspended if the company's situation financially deteriorates. Usually the management board is obliged to file for bankruptcy, but it has been suspended until 2 months from the end of the state of emergency. So now the most popular measure that we have at the moment is the salary compensation paid by the unemployment insurance fund, and this is basically what we call the 30 plus 30 plus 30 criteria. The unemployment insurance fund would cover up to 70% of the employee's monthly salary in case the company applying for it corresponds to 2 out of 3 criteria. Namely, there has to be a drop of at least 30% in the turnover, or the company has not been able to provide work for at least 30% of its employees and has applied these Article 35 or 37 measures that we talked about, or the salary of at least 30% of employees has been decreased in the extent of at least 30%, and again these Article 35 or 37 measures have been applied. The subsidy is available for 2 months in the period of March and May. There are now discussions that maybe this subsidy will be continued, but probably the eligibility criteria would be changed a little bit, because it's a rather expensive subsidy for the state. So far already 26 million euros have been paid out, and there have a little over 6,000 companies who have applied for it, and so maybe the criteria would be changed so that the turnover that qualifies, the reduction in turnover that qualifies would be 50%, or maybe the different sectors will be targeted, but that is not yet clear. So the possible amount that the unemployment insurance fund compensates is up to 1,000 euros gross per month per employee, but the employer also has to pay its own contribution. It's at least 150 euros per month, and the tax also needs to be paid from the employer's part, and the unemployment insurance fund will be paid from the part that they pay out. And what companies who use this measure should remember is that there is a prohibition to terminate contracts due to redundancy in the months when they apply for the subsidy, and also within 1 month after using the subsidy. And the application is filed by the employer, but the payout is made to the employee, so in order to prevent any misuse of the subsidy. So, but there are already a lot of problems also discovered with this, because unemployment insurance fund has discovered that companies have tried to retroactively change their turnovers of last year's, or change the salaries retroactively, or provided false data. So there have been also already cases of misuse. And so finally, let's have a look at the teleworking. Next slide, please. So telework is the new normal everywhere, especially for those employees who are working in offices and who can take their work home, so to say. In Estonia, telework is not regulated in any way in our law. There is only a reference in the Employment Contracts Act saying that if the employee is doing telework, this means performing his or her duties outside the employer's premises, then this has to be mentioned in the employment contract, and that is basically it. So telework is always voluntary and it requires prior agreement. So the employer cannot request the employee or order the employee to go and work from home, and similarly the employee cannot request working from home as well. So there needs to be a prior agreement. And as said, there is no specific guidance what this agreement should contain. But what is important to remember is that the employer always remains responsible for all usual employer's obligation, although it might be in some cases difficult to perform these obligations because the employee is away from the premises and as one's home cannot be, so to say, violated. So the employer cannot always go and check on what the employee is doing. So there are some hurdles that have to be somehow overcome with this situation. So I always recommend that when you want to use telework, agree with the employee. Don't just send him or her home, but consider and agree on the most important aspects that need to be taken care of. Employer still has the obligation to observe that working hours are followed, and the employer has to record the working hours, so there must be in place a system how to do it. You should also instruct how communication with employer, colleagues and clients would take place. Are there any obligations to attend meetings or check-ins? You should agree how instructions are given, how you monitor that actually the employee fulfills the tasks and follows the instructions. You should decide how to maintain the protection of business secrets and personal data also in the home office, how IT security is ensured, if you have provided the employees with some laptop or some other devices, how employers' property should be kept. You should also decide and agree whether you compensate costs related to telework, and if yes, then which costs. And in case the employment relationship ends during the time the employee is working from home, then how you would get back the property that you have handed over, how the work in progress is handed over to colleagues, and how the termination documents are delivered. So these are all very important things to keep in mind and agree upon. And the most important obligation that the employer has, that it still remains responsible for occupational health and safety. And it's quite obvious that you cannot go and visit the employee's home each time. So, but you still have to conduct this risk assessment prior to allowing homework. So you can agree that you go and have a look at the home office, or you just base the risk assessment on conversation with the employee, and you can have a checklist in place for assessing the risks. And after this risk assessment, you also, like in normal work environment, you have to have an action plan in place that would state how the risks that are in the home office have to be mitigated or prevented, and you have to instruct the employee on proper work methods and ergonomics and all things like that, and you should also have proof that you have done so. And if necessary, you must assist with adapting the workplace and provide required protective devices and so on. And some of the costs can be made tax-free, provided that there is written documentation about it and proof about it. So, yeah, basically, it's difficult to arrange the occupational health and safety part of teleworking, but still, it's recommendable to do it to prevent any problems or disputes later on. Because if this teleworking arrangement goes on for a long time, you really don't know what the situation with the work desk or whatever there is in home offices, and there could be some work-related diseases developing later on. So it's best to take care of those things.